Right now, millions of families waiting for a green card could be affected by a major immigration update in 2026. If you or someone in your family has a pending family visa petition, what I am about to explain could completely change how long you have to wait. A significant shift is underway in the United States family immigration system, and millions of families separated by borders are now watching closely as developments unfold throughout 2026. Immigration authorities, lawmakers, and advocacy groups have turned their attention to the mounting backlog affecting family-based visa categories, prompting discussions that could reshape how quickly relatives reunite on American soil. For petitioners who submitted applications years ago and beneficiaries who have endured prolonged separation from loved ones, the current moment represents a critical juncture. Policy conversations in Washington have intensified, operational adjustments within federal agencies have accelerated, and monthly Visa Bulletin movements have captured renewed interest from immigration observers worldwide. The convergence of these factors suggests that families who remain vigilant and prepared may encounter opportunities that seemed distant just months ago. The scope of this situation cannot be overstated. According to estimates from immigration policy analysts, millions of approved petitions remain pending in family preference categories, with some applicants facing waiting periods that stretch beyond 2 decades. The human cost of these delays extends far beyond statistics. Parents have watched children grow up through video calls, spouses have maintained marriages across continents, siblings have missed funerals, weddings, and countless ordinary moments that define family life. Understanding how the family immigration framework operates provides essential context for grasping why recent developments carry such weight. The Immigration and Nationality Act established two distinct pathways for family-based immigration, and the distinction between them fundamentally determines how long applicants must wait. The first pathway covers immediate relatives of United States citizens. This category encompasses spouses, unmarried children under 21 years of age, and parents of adult American citizens. Crucially, Congress exempted this category from annual numerical limitations. No cap exists on how many immediate relative visas can be issued in any given fiscal year. This means that once petition approval and administrative processing conclude, visa issuance can proceed without waiting for a priority date to become current. Processing delays still occur, but they stem from administrative workload rather than visa unavailability. The second pathway presents a starkly different reality. Family preference categories face strict annual caps that Congress established decades ago. These categories include unmarried adult sons and daughters of United States citizens, spouses and children of lawful permanent residents, unmarried adult sons and daughters of permanent residents, married sons and daughters of American citizens, and siblings of adult United States citizens. When applications in these categories exceed available visa numbers, a queue forms. That queue has grown substantially over the years as demand has consistently outpaced supply. The priority date system governs placement within this queue. When a petitioner files an immigrant petition on behalf of a qualifying relative, the date that petition reaches the immigration agency becomes the priority date. This date essentially marks the applicant's place in line. Years later, when that priority date becomes current according to the monthly Visa Bulletin, the case can advance toward final processing and visa issuance. The Department of State releases the Visa Bulletin each month, providing updated cutoff dates for each preference category and each country or region subject to per-country limits. Immigration attorneys, petitioners, and beneficiaries scrutinize this publication to determine whether their cases can progress. When dates advance more rapidly than historical patterns suggested, it can suddenly unlock movement for families who had resigned themselves to additional years of waiting. Recent months have witnessed notable fluctuations in several preference categories. Analysts tracking Visa Bulletin patterns have observed forward movement in certain family categories that had remained stagnant for extended periods. While predicting future bulletin movements remains inherently speculative, the trajectory has sparked cautious optimism among some immigration practitioners. Beyond monthly bulletin movements, broader policy discussions have emerged that could fundamentally alter the landscape. Congressional members from across the political spectrum have acknowledged that the current system fails to address modern realities. The numerical limits established decades ago have not kept pace with immigration demand, creating backlogs that serve neither families nor national interests. One proposal that has gained traction involves recapturing unused visa numbers from previous fiscal years. Historical records indicate that in certain years, authorized visa numbers went unused. Advocates argue that these numbers should be reallocated to current applicants, effectively increasing annual availability without requiring changes to underlying statutory limits. Legislation addressing this concept has circulated through committee discussions, though the path to enactment remains uncertain. The legislative process presents inherent obstacles. Any measure altering immigration policy must secure approval in both the House of Representatives and the Senate before reaching the presidential desk for signature. Political dynamics, competing priorities, and procedural hurdles can delay or derail even proposals that enjoy bipartisan support. Nevertheless, the sustained attention to family immigration backlogs signals that momentum for potential reforms continues building. Operational developments within federal agencies have paralleled these policy discussions. United States Citizenship and Immigration Services and the Department of State both administer critical components of the family visa process, and both agencies have undertaken efforts to address processing inefficiencies. The disruptions that emerged during the global health crisis created unprecedented backlogs across immigration categories. Consular posts worldwide suspended routine visa processing for extended periods. Service centers faced workforce constraints and shifted operational protocols. The cumulative effect substantially increased wait times for applicants already enduring lengthy queues. Recovery efforts have gradually gained traction. Consular sections at embassies and consulates have expanded interview capacity in numerous locations. Digital processing initiatives have streamlined certain administrative functions. Staffing levels have stabilized at many facilities, enabling higher case throughput. While significant backlogs persist, the trajectory suggests incremental improvement. For families awaiting immigrant visa interviews abroad, consular capacity represents a decisive factor. Even when a priority date becomes current and all documentation has been submitted, the case cannot conclude until the beneficiary appears for an in-person interview. In countries with heavy visa demand, appointment availability has historically constrained the pace at which cases move toward completion. The expansion of consular operations therefore carries direct implications for waiting families. A procedural nuance that many applicants overlook involves the two separate charts published in each visa bulletin. The final action dates chart indicates when visas can actually be issued. The dates for filing chart may permit certain applicants to take preliminary steps before their final action date becomes current. When United States Citizenship and Immigration Services authorizes use of the dates for filing chart for adjustment of status applications filed domestically, eligible applicants already present in the United States may submit their adjustment applications earlier than otherwise possible. This can provide significant advantages, including eligibility for work authorization and advanced parole travel documents while the case remains pending. However, the agency determines monthly which chart adjustment applicants may use. This determination can change from month to month based on workload assessments and other factors. Consequently, applicants must monitor announcements each month to understand whether the dates for filing chart applies to their category. The extended waiting periods that characterize family preference categories create particular challenges for maintaining case readiness. Many applicants assume that once their petition has been approved, no further action is required until their priority date becomes current. This assumption frequently proves costly. Cases pending at the National Visa Center require continuous attention. Civil documents, including birth certificates, police clearances, and passports, must remain valid and current. The affidavit of support from the petitioning sponsor must reflect accurate financial information. Contact details on file must enable reliable communication. When any of these elements becomes outdated or expires, processing delays result. The National Visa Center communicates with applicants electronically, sending instructions, requests for evidence, and scheduling notices via email. If applicants fail to maintain current contact information or neglect to monitor their accounts, critical correspondence may go unnoticed. When priority dates become current, response time matters. Applicants who act promptly often secure earlier interview appointments than those who delay. Legal complexities can further complicate certain cases. While many family visa applications proceed straightforwardly, others involve circumstances that trigger inadmissibility grounds. Previous immigration violations, periods of unlawful presence in the United States, criminal history, or prior removal orders can create barriers to visa issuance. In such situations, waiver applications may offer a pathway forward. The waiver process requires demonstrating extreme hardship to qualifying relatives and presenting compelling documentation supporting the request. These applications demand careful legal analysis and thorough preparation. Applicants who attempt to navigate complex inadmissibility issues without proper guidance frequently encounter denials or extended administrative processing. The protracted nature of family immigration waiting periods has unfortunately attracted fraudulent actors seeking to exploit vulnerable applicants. Individuals falsely claiming special government connections or guaranteed expedited processing have targeted families desperate for resolution. These schemes extract money while delivering nothing legitimate. Immigration authorities have repeatedly warned that no private party can accelerate cases through unofficial channels or bypass established procedures. Legitimate immigration processes follow prescribed legal frameworks, and promises suggesting otherwise should trigger immediate skepticism. Families seeking guidance should consult licensed attorneys or Department of Justice accredited representatives who operate within ethical and legal boundaries. Despite the frustrations inherent in the current system, circumstances suggest grounds for measured hope. The combination of legislative attention, agency improvements, and continued Visa Bulletin movement indicates that progress remains achievable. Families who have persevered through years of separation may finally witness tangible advancement as the system continues adapting. The essential lesson for anyone navigating this process centers on preparation and engagement. Passive waiting rarely serves applicants well. Those who monitor developments, maintain complete documentation, verify their information remains current, and understand procedural requirements position themselves advantageously when opportunities emerge. Immigration policy and administrative priorities evolve continuously. Provisions that appear unlikely today may materialize tomorrow. Bulletin movements that seemed improbable may suddenly occur. Families who remain informed and ready can capitalize on favorable developments without delay. The path toward family reunification demands patience that tests human limits. Years of separation exact emotional tolls that statistics cannot capture. Yet every step forward in the process brings families closer to the moment when geography no longer divides them. Throughout 2026 and the period ahead, new developments will continue shaping the family immigration landscape. Legislative outcomes, agency initiatives, and bulletin movements will collectively determine how quickly various categories advance. While individual case timelines remain impossible to guarantee, understanding the system and preparing for each phase places families in optimal position. For the millions of people worldwide whose lives remain suspended while awaiting family visas, this message resonates clearly. Engagement with the process produces better outcomes than disengagement. Verification of case status, documentation currency, and procedural awareness can accelerate final resolution when the moment arrives. The American family immigration system was designed to reunite families. The implementation of that design has proven imperfect, creating waiting periods that challenge fundamental values of family unity. Yet the principle underlying the system persists, and families who navigate its requirements with diligence and preparation ultimately reach their destination. As authorities continue addressing backlogs, as policymakers debate reforms, and as agencies refine their operations, the landscape will shift in ways that create new opportunities. The families positioned to benefit from those shifts will be those who have maintained vigilance, stayed informed, and prepared their cases thoroughly. For them, the long-awaited chapter of life together in the United States draws incrementally nearer with each passing development.